Armed insurgency in the Indian-administered Kashmir has been an intermittent and fluctuating phenomenon since the late 1980s. However, the disputed territory has witnessed a sudden surge of violence since last few years. It is also pertinent to mention that India stripped the Indian-administered Kashmir of its status as a semi-autonomous entity in August 2019 and attempted to bring the disputed region within the ambit of the Indian Union. This predictably lent fuel to the fire of resistance on behalf of the Indian militant groups battling for independence in the Indian administered Kashmir against the Indian state. Moreover, India has traditionally placed the responsibility for sponsoring militant groups and activities in the Indian administered Kashmir on Pakistan. Accordingly, the entire Indian administered Kashmir is heavily populated by Indian armed forces in order to defeat the allegedly Pakistan-backed militant/separatist groups. In this regard, it is important to analyze whether there is an ongoing armed conflict in the Indian administered Kashmir, considering international law. Hence, this video will consider who are the non-state armed groups in the Indian administered Kashmir and whether there is an armed conflict in the IAK. As indicated in the opening monologue, that the answer to the question whether there is an armed conflict in the Indian administered Kashmir will determine whether the protections provided under the international humanitarian law are applicable in the situation of the Indian administered Kashmir or not. So in this regard, there are two widely established facts with respect to the Indian administered Kashmir or the IAK. Firstly, there are militant/separatist groups operating in the Indian administered Kashmir, and there has been violence between the said militant groups and the Indian armed forces. So, firstly, who are some of the major groups operating in the Indian administered Kashmir? Well, number one is the Hizbul Mujahideen. Hizbul Mujahideen emerged during 1988 protests upon the controversial 1987 Kashmir state elections. Now, Hizbul Mujahideen has become the largest indigenous rebel groups operating in the IAK. Number two is the Jaish-e-Muhammad. Jaish-e-Muhammad was formed in the year 2000 by Masood Azhar, and it has been the focal point of India's claims that Pakistan has been sponsoring attacks in the Indian administered Kashmir. Thirdly is Lashkar-e-Taiba, was formed by Hafiz Muhammad Saeed. It is also one of the focal points of India's claims that Pakistan has been sponsoring attacks and sending fighters in the Indian administered Kashmir. And of course, according to the estimates of the Indian security forces, it has the largest presence in the Indian administered Kashmir, namely 129 fighters, according to one estimate from the year 2019. Moving on to the question whether there is an armed conflict in the Indian administered Kashmir, of course, the presence of non-state actors would bring us within the territory of non-international armed conflict. However, firstly, we need to define what is an international armed conflict, or what is armed conflict. So the definition was provided by the International Court Criminal Tribunal of Yugoslavia, or ICTY Appeals Chamber, in the case of Prosecutor versus Tadic. The tribunal held that an armed conflict exists whenever there is a resort to armed force between states or protracted armed violence between governmental authorities and organized armed groups, or between such groups within a state. Considering the definition in Tadic, there are two types of armed conflicts in international law: the international armed conflict, which is between states, and non-international armed conflict involving non-state parties, non-state armed groups, and the states, or between or among the non-state armed groups. According to Tadich, the non-international armed conflict requires two conditions, or it has two criteria, and number one is protracted armed violence, which is the intensity of violence, and number two is organization of non-state parties to non-international armed conflict, or NIAC. Before moving forward, it is important to mention the international legal framework which governs NIAC. It is constituted of Common Article 3 of the 1949 Geneva Conventions, the Additional Protocol 2 to the Geneva Conventions, and customary international humanitarian law. Particularly, CA3 or Common Article 3 applies to an armed conflict not of an international character occurring in the territory of one of the high contracting parties, for instance India. However, India is yet to become party to the AP2 or Additional Protocol 2. So in this regard, the relevant international legal framework with respect to IAK is the customary IHL and CA3 of the Geneva Conventions. The following video will consider whether there is an armed conflict in the Indian administered Kashmir, and what are the two twin criteria which was stated in Tadich, and whether those criteria, the criteria is fulfilled in the situation of the Indian administered Kashmir. So the first criterion is the criterion of organization. It is stated by the ICTY in Haradinaj case that an armed conflict exists only between parties that are sufficiently organized to confront each other with military means. So it is presumed that governmental authorities satisfy the threshold of organization. However, for non-state armed groups, the ICTY are recognized following indicative factors to be taken into consideration. Namely, the existence of a command structure and disciplinary rules and mechanisms within the group, the existence of a headquarter, the fact that the group controls a certain territory, the ability of the group to gain access to weapons, other military equipment, recruits, and military training, its ability to plan, coordinate, and carry out military operations, including troop movements and logistics, its ability to define a unified military strategy and use military tactics, and its ability to speak with one voice and negotiate and conclude agreements such as ceasefire or peace accord. So in this regard, the militant/separatist groups conducting attacks in the Indian administered Kashmir, such as Hizbul Mujahideen, would fulfill most, if not all, the indicative factors. However, it is doubtful whether any of the opposition groups has a control over a certain territory in the Indian administered Kashmir. However, it is important to understand that the phrase indicative factors mean that none of the factors are themselves essential to establish or meet the criterion of organization. They are merely indicative of the fact that a certain military group or armed group has the required organization for the purpose of armed conflict. Moving on to second criterion of intensity. It is mentioned in the introduction that armed insurgency in the Indian administered Kashmir has been an intermittent and fluctuating phenomenon since the late 1980s. However, past few years have seen a sudden surge in violence between non-state armed groups and the Indian armed forces. However, the question we need to ask, would this sporadic and fluctuating violence be enough to meet the criterion of intensity as provided in Tadich? So the ICTY in Haradinaj interpreted protracted armed violence, which is a phrase that the ICTY itself used in Tadich. So it interpreted that phrase as referring to intensity of armed conflict and not to duration. So the trial chamber relied upon indicative factors in order to assess the intensity criterion, such as the number, duration, and intensity of individual confrontations, the type of weapons and other military equipment used, the number and caliber of munitions fired, the number of persons and type of forces partaking in the fighting, the number of casualties, the extent of material destruction, the number of civilians fleeing combat zones. The involvement of the UN Security Council may also be a reflection of the intensity of our conflict. However, not unlike the organizational criterion, the indicative factors, none of the indicative factors with respect to the intensity criterion are themselves essential to establish the requisite intensity of an armed conflict. They are merely indicators of the fact whether the intensity is enough to fulfill the criterion of intensity under the Tadich twin requirements. So it is arguable that the intensity of violence in IAK, owing to its sporadic and fluctuating nature, cannot reach the threshold for the purpose of a non-international armed conflict. However, the International Criminal Court in the case of Jermaine Katanga employed a more global assessment of intensity to the situation in the Eastern Democratic Republic of Congo, as indicated by Jean Kleffner in one of his journal articles. And the International Criminal Court in the case of Katanga considered various attacks cumulatively in order to establish intensity for the purpose of NIAC. So court considered various different attacks conducted by various different armed groups and state forces at different time, and however the attacks were considered within territorial and temporal confines, and so the effect of all those attacks within a certain territory within a particular period of time, the effects were considered cumulatively, and that cumulative effect reached that criterion of intensity for the purpose of establishing a non-international armed conflict in the Eastern DRC. So the court stated that with specific reference to its foregoing review of the attacks that followed assault on Bogoro, the chamber finds that the armed conflict was both protracted and intense, owing inter alia to its duration and the volume of attacks perpetrated throughout the territory of Ituri from January 2002 to May 2003. Thus, in the chamber's view, the evidence before it suffices to fulfill the intensity of the conflict requirement. It further notes that the United Nations Security Council recognized the existence of this armed conflict and adopted numerous resolutions on the matter. And the International Committee of Red Cross adopted a similar approach with respect to the situation in Syria. So ICRC concluded that there is currently a non-international armed conflict occurring in Syria, opposing government forces and a number of organized armed opposition groups operating in several parts of the country, including but not limited to Homs, Idlib, and Hama. Thus, hostilities between these parties, wherever they may occur in Syria, are subject to the rules of international humanitarian law. These rules impose limits on how the fighting can be conducted, with the aim of protecting the civilian population and persons not or no longer directly participating in the hostilities. So the cumulative approach adopted by the International Criminal Court in the case of Jermaine Katanga is considered a suitable approach for complex situations involving numerous armed groups and fluctuating violence, as in the IAK, and it is considered suitable by Jean Kleffner. So the situation in the IAK is not very different from what is happening in Syria or what happened in the eastern DRC. So there are number of groups that are fighting the state forces, and incidents of violence are fluctuating and sporadic and intermittent, and they change with time. So but the cumulative effect of all the violence and all the destruction to life and property that it caused can be taken as enough to reach the threshold of intensity required for the purpose of establishing non-international armed conflict. Also, I would invite you to review the timeline of violent incidents for the last 30 years. The timeline can be found in any one of the news platforms and websites. And after reviewing that timeline, there is a case for the argument that the cumulative effect of violence can be considered as enough to reach the threshold of intensity for the purpose of NAYAC to exist in the Indian administered Kashmir. So in conclusion, it can be argued that there is a case for NAYAC in the Indian administered Kashmir because there are organized groups fighting the Indian armed forces, and the intensity of violence when considered when we consider the last 30 years and all the death and destruction, all the incidents of violence have caused in Kashmir, the cumulative effect of that of the violence for the past 30 years can reach the threshold of intensity. So if the situation in Kashmir amounts to a non-international armed conflict, the CA3 of the Geneva Conventions and the customary international humanitarian law will be applicable. It is important to know that the IHL seeks to protect individuals who are not directly participating or no longer participating in the ongoing conflict, such as civilians. However, the IHL's application can be further strengthened by co-application of international human rights law as well. On the other side of the argument, there are those who can argue that that considering the 30 years of fluctuating violence in Kashmir might be stretching the law a bit too far, because we need to remember that the International Criminal Court in the case of Katanga considered only 1 year of violence. So this might require an even closer examination of facts on the ground, facts which might be sometimes shrouded in mystery, particularly in the case of Indian administered Kashmir. So this will be enough for now. This was a very brief analysis of a very complex situation. I thank you.